you can see the slides. And good morning also from my side. My name is Silla Sepp. I serve as the head of urban data ecosystems at the Finna Center for Smart Cities, which is one of the partners in the project. We've been in touch in the past around the open calls period, and then later on with the previous governance trainings. We haven't met in person yet. Nice to meet you, and good to have you here. This training is then focusing on regulatory compliance and also the contractual framework around the data spaces that, well, you are developing, and also we as together are working towards the common European data space. And while this is part of the governance training program, we wanted to also highlight some of the kind of reasons for actually having such a training. For the second and third round pilots, we, as you know, did a bit of a different type of route. We had the introductory sessions earlier this spring, and then had this in-person boot camp just last month in Ljubljana, where we focus more on the business aspects of data spaces. We did look into a little bit also the governance aspects, but not too much into the regulatory and the legal points. So this is something that we wanted to still do and keep now online, because this is still one of the very important aspects of data spaces developments. We start by having a little bit of a provocation also. We've looked into the self-assessment surveys of the various pilots already, and also noticed that, at least according to your descriptions or the responses that have been given, there seems to be that the work on addressing the ethical challenges that was pointed out during the application phase hasn't actually been you haven't started really work on that, at least according to the descriptions. As the ethics and data protection self-assessment looked into also aspects of legal and regulatory compliance, this is something that we would need to also continue elaborating. Also in the self-assessment surveys, we noticed that there hasn't been much, let's say, identification of different types of legal challenges in your data space developments, and also that generally challenges haven't been described. Now, we could look at this also from the perspective that everything is going as planned. There are no challenges, but being a little bit more conservative and maybe looking at the various kinds of risks that there are around data space developments, and also seeing that it's very much in flux, very also in early stages. We'd like to also discuss this together with you throughout this session to understand what are some of the different types of areas that would need to be looked into a little bit more in detail, and then also try to, of course, already start finding some of the mechanisms or solutions to these challenges as well. So altogether in this context, the whole objective of this training is to firstly understand the kind of regulatory landscape around in the European Union, especially in looking at the digital landscape, and how to navigate through those, not looking at any of the individual regulations very much in detail, but understanding more how to kind of navigate through them and also see them as complementary to each other. The second objective is to also understand the scope of these acts according to your data space. Depending on your scope, the data that you include, the actions that you also want to take up, different acts might be more relevant than others. The third objective is to also look at the contractual framework and understand what types of different type of contracts and agreements might be needed to really make it legally valid and also sustainable in the long run. And the fourth one, of course, to identify any types of challenges that you might have, to then start thinking about how might you and we together start also resolving those. And in terms of the objectives and the whole session, this is very much based on the work that has been done by the Data Spaces Support Center already with the elaboration of the blueprint version 2.0. So as you know, the support center is releasing the blueprint every 6 months. Now it hasn't been released for this fall, but the third version 3.0 will be coming out early next year. So we'll still keep on looking at what type of evolution is coming up there. But you might, also that we have already updated the blueprint for data spaces for smart communities. So it's these training are very much based on those iterations. The building blocks, as you know, is on the regulatory compliance and the contractual framework. So we'll look into those two points more in detail throughout the session. And in terms of the whole agenda, I'll give the floor right away to our colleague Genoveva Gil Garcia from Serendipity to provide the presentation around the regulatory landscape. Then we will break into group discussions. And after that, we will have a short presentation by myself around the contractual framework, after which we can break into groups based on your pilot groups, and we will close by 12 o'clock Central European time. With that, I see that Genoveva has already started the screen sharing, so I'll give the word over to you, please.
Thank you, Sile, and good morning, everyone. It is very nice to see that we have quite a full room. So this is very happy news for us. So it seems that, our objective to raise awareness is already in the good track. Good morning, everyone. Thanks for joining the session. My name is Genoveva Gil, and I'm gonna be driving you through the regulatory landscape today. I work as a tech law researcher and project manager at Serendipity. And as Sile was mentioning, the main purpose for today is to start raising awareness and to also help you start identifying challenges that will also help you identify the right questions regarding the regulatory landscape and contractual framework relevant for your data space. So there will be an interactive workshop after my presentation. So please know that all the clusters and the different acts that we'll be going through, this will be relevant for the workshop. So if you start identifying already certain questions that you would like to discuss with your colleagues here present today, then I also invite you to have a notebook close to you so that you can already start preparing for the workshop. So since we don't have too much time, I will go right away into the presentation. And I would like to first start with a bit of the context. Just give me a second, I need to, okay. This, like this, okay. So we are in the middle of the digital decade. As you know, as part of the previous commission, one of the priorities was the so-called Europe Fit for the Digital Age. And under this priority, there was the publication and the drafting of the Digital Decade Policy Program, which guides Europe's digital transformation towards 2030. And this is seen as an enabler of the green transition. And as you might already know, one of the strategies and legislative initiatives under the digital decade is the European Strategy for Data, with acts like the Data Governance Act, the Data Act, or the Open Data Directive under this umbrella. You might have heard already about the new Data Union strategy, which is under public consultation, and that might have an impact also on the simplification or let's say even amendment of these acts. But so far, let's keep it with what we have right now applicable and enforced, and then we will see what are the future developments. And hopefully, if this has an impact on our future work, we will also be able to keep track on this and let you know. So as part of the European strategy for data, the main objectives of this strategy is to create a single market for data, For this, we need to create trust in data sharing so that there is also sovereignty over data. And here cities play a very important role because they are seen as enablers of the data economy. But of course, all initiatives come with challenges, and these challenges are mainly interoperability, building trust around this data sharing, and also the lack of a business model. So the proposal from the Commission to address these challenges and how to achieve then these objectives are to build common European data spaces. And today, of course, we are focusing on the European data space for smart communities. And we are gonna look into the digital legislation that would be applicable to our European data space for smart communities. So I already start with a bit of the disclaimer. All these clusters that you see here in the screen are a high-level overview and that are relevant to our specific context. The different legislation that you see under the cluster might not be exhaustive. This is also exemplificative. And it's also important that you know that at some point you will need to also look into the national legislation and also specific acts that might be applicable depending on your concrete use case. Because, for instance, here you don't see the domain-specific ones. But what we will see and start recognizing during this session is that all these clusters are interrelated and they all need each other and they all have a sense and the purpose why they are here presented in this slide. So as I said in the previous slide, you have the more high-level overview, which is kind of cross-sectorial, but there is also domain-specific legislation that we are not going to focus on today because then we could really have a very, very long session. But you already had training on EU environmental regulations dedicated to just these EU environmental regulations, which have already concluded. But in any case, I invite you also to revisit the materials that are probably available in your pilots folder. If you have any questions, you can always ask your mentor where to find those materials. But then how can we navigate through the different clusters of legislation, the different acts? How do they interrelate with each other? So here's where we present you a methodology that is inspired by the methodology from the Data Spaces Support Center blueprint, the 2.0 in this case. And here we talk about triggers. We think it's also very pedagogical methodology because thinking about what triggers the application of legislation helps you also identify and go step by step on defining what are the different acts that are relevant and that are under the scope of your data space. So the classification from the Data Spaces Support Center and also what we added here, the methodology invites you to think about the types of data, the types of participants, the use case, and the technology that you're using in your data space. So regarding the types of data, there can be different questions to ask yourself about. So for instance, am I processing personal data or will I process personal data at some point? Is this personal data sensitive? Is there proprietary data? Is there private held data? So depending on the answer to these questions, then certain clusters and acts will be triggered or not. We will see it in a minute. And then as for the participants, same types of questions. Are there public sector bodies involved? Are there providers of data processing services involved? Are there any kinds of consumers that are participants of the data space? As for the use case, normally this will trigger the domain-specific legislation. Am I in the health sector? Then probably the European Health Data Space Regulation will apply. am I in the green sector? Then I need to look into the green legislation. And the technology used. This is something that we've added with respect to the Data Spaces Support Center methodology blueprint, because this is also useful to think about, am I gonna use the data coming from the data space to feed an AI system? Am I collecting data through the support of IoT sensors that then will go to my data space? Am I gonna implement an electronic identification scheme? So these questions, right now, maybe you're not linking them to the different acts, but then if you start, let's say, building the connection between the triggers and the acts, you can have a picture similar to this one. Of course, this is very high level to give you an example, a visual image of how this could look like. But in case of types of data, if I'm processing personal data, then for sure the privacy and data protection cluster will apply. So the GDPR in this case. If I'm processing if I'm using open data within my data space, then the Open Data Directive and hence the data legislation and interoperability cluster would apply. If the data is proprietary, then the IP rights cluster would be triggered. As for the participants, same. If there is a consumer involved, then the consumer protection and regulation of platforms cluster would be triggered, and so on for, let's say, the technology used. If I'm gonna involve an AI system in my use case, then the AI Act would apply. And then, well, you see below here at this kind of horizontal arrow that this signifies that most probably, depending, regardless of the types of data participant use cases technology used, these clusters, the electronic identification and trust services, cybersecurity, and contract law, would apply to all data spaces, because all data spaces would require an identity and access management system, and most probably then I will also need then an electronic identification scheme. Cybersecurity, because we are always talking about network and information systems that are involved in the data space, so for sure cybersecurity will be needed. And then contract law, because in order to regulate and make sure that the different obligations are enshrined in contract, and then we need also a contractual framework. And we will also discuss and have the opportunity to discuss about the contractual framework later on in this session. So in the following slides, since we don't have too much time, we won't go into too much detail because of time constraints, of course, and this is just to start triggering the conversation and let you start thinking about challenges and discuss with each other. We're gonna focus on certain acts, the ones that we consider most relevant and, let's say, the most challenging, perhaps, per cluster. So without further ado, I'll start then with the privacy and the data protection cluster to give you a bit of an overview and to trigger also your attention, to drive your attention to certain key aspects. So as I said, if we follow the methodology of which cluster would apply or not to my data space, then in order to see if the GDPR in this case or the privacy apply, I need to ask myself if I'm gonna be processing or if I'm processing personal data. If the answer is yes, then the GDPR applies and all the set of obligations and requirements of this regulation as well. If this is in the electronic communications sector, let's say a website is involved or an application, then the e-privacy directive, which is lex specialis, would apply. But in order to understand if the GDPR applies, I need to understand a very key concept of this regulation, which is personal data. It seems, it looks like it's very easy to understand what personal data is, but sometimes it's even challenging because the definition given by the GDPR is quite broad, and in that sense, it's also very protective. Because personal data is defined as any information relating to an identified or identifiable natural person who can be identified directly or indirectly. So there might be certain data points that for you don't indicate that this is personal data. But for instance, an example I always like to give is that, for instance, an IP address isolated as a data point can be personal data, because if you merge it with other with other information, then you could be able to identify an individual, because the IP address relates to the location, relates to a device that it's in a location, and this location is linked to an individual, of course. So this definition is very important to have in mind. And who does it apply to? Then we have two types of main profiles here, which are the controllers, which define the purposes and means of processing personal data, and the processors of personal data, who process data on behalf of the controller. A very easy example is, for instance, of a processor is, for instance, a cloud service provider. So Amazon Web Services, which has been recently in the news, would be a processor of anyone who contracts their services and transfers their data to be hosted under their service. So very important to highlight here is that the GDPR applies whenever there is personal data. But if this data is anonymized, then it would not apply, it would not be applicable. But here it's very important to know about the risk of re-identification, because there can be certain personal data that in principle is anonymized, but there can always be a risk of identifying or singling out an individual if certain things, or let's say certain events happen in the future. Technology evolves. There are data sets that come available in the public domain that can be merged with these, in principle, anonymized personal data that then allow me to identify someone. So it's very important to conduct, if I'm working, let's say, or I'm in a project where I'm using anonymized personal data, to conduct frequent re-identification tests to avoid, in the end, the risk of a personal data breach. So certain questions that you could ask yourself to detect whether there is this risk is to understand whether their data set contains directly or indirectly identifiable data, if there are any foreseeable techniques or technologies that can undo the anonymization, because I might have used a certain technique that is very advanced, but then the technology evolves so fast there could be maybe a way to reverse this process. And a good example here that you see also in the visual for the last question is that let's think about a public sector body that is controller of certain personal data, and that it uses for its own purposes, legitimate purposes, of course. But then they want to anonymize this personal data in order to make it open data. So they do this process, and it is very important to also analyze this risk of re-identification, because then this open data would be available to any reuser in the public domain. And we need to think about here if there might be other data sets available in the public domain that could be linked to this data set that was in principle anonymized. So it is very important to have this in mind before considering that certain set of previously personal data can be actually considered open data. So just to have this in mind. And of course, if the GDPR applies, then there are certain obligations that you need to look into This is very high level, and of course we would need to analyze case by case certain obligations, because there might be certain exceptions. But let's also highlight here, for instance, the importance of the data processing agreement between the controller and the processor, so that the obligations are very clearly set in this agreement. Or also the conduction of a data protection impact assessment. This is something that maybe if you are processing personal data in your pilot, you will need to conduct, especially if there is a high risk, if you meet also the requirements of Article 35 of the GDPR in this case, if there is a high risk for fundamental rights of individuals, and also if you're also using a new technology. And this would be it for the privacy and data protection cluster, main highlights I wanted to underline. And as for the cybersecurity, it is one of the four main pillars of the European data strategy. We always say that cybersecurity go in hand with privacy and data protection, with the protection of personal data, of course, because if we need to implement certain technical and organizational measures to protect the data, cybersecurity is going to be highly important. And here we're going to talk a bit about the infamous NIS2 directive. Of course, there was a previous one. But the NIS2, the transposition deadline was 17th of October last year, but there were also certain member states that were delayed in the transposition. But what is cybersecurity? And here we take the definition from the Cybersecurity Act. It's all the activities necessary to protect network and information systems, the users of such systems, and other persons affected by cyber threats. So definitely here in our data spaces, we're talking about network and information systems, and this cluster is very relevant to all data spaces. The goal of the NIS2 directive is to achieve a high common level of cybersecurity in the EU. And it identifies two main types of entities to which this directive is applicable to. And these are the essential entities and the important entities. You have a whole list. There's even an annex where you can see who are considered essential entities and important entities. But here I highlighted the ones that are more relevant for you to know. So essential entity, the public administration is considered an essential entity. And also entities related to digital infrastructure, transport, energy. And regarding public administration, it's defined as considered as at the regional level. And for the local level, you need to look into the national transposition. Then for important entities, we have the ones related to food production, digital providers, and research, among others. But what are the requirements and what does it regulate? So it includes cybersecurity risk management measures, like for instance, ensuring business continuity. So measures to ensure business continuity, like backup management, disaster recovery, crisis management. Then also requirements regarding supply chain security, policies for the use of cryptography, or if applicable, encryption. Then HR security, access control, cybersecurity training. And then it also includes these important incident notification requirements to report about an incident to the computer security incident response team. This is also a bit, again, high level. It's not exhaustive, but you have there the articles, the provisions of the directive to look into more detail, but also to give you a gist of it. We move on to the data legislation and interoperability cluster. Here we would like to mainly highlight the Open Data Directive, the Data Governance Act, and Data Act. Here you see them in comparison so that you understand the differences between these three very important acts nowadays, and it's been debated and discussed about them a lot, and I know that most of you have already looked into them because of your answers to the self-assessment survey. But in any case, as a reminder, what is the scope of the data directive? And again, if we think about the triggers of these act in this case, if I'm processing public sector data, which is considered open, then this directive would apply and all the requirements underneath. But then who has to comply with this directive? And these are public sector bodies governed by public law, public undertakings, universities. So again, if here we would think about the triggers as type of participants and types of data that are being handled and processed within the data space. Then the Data Governance Act is also about the reuse of public sector data, but in this case, it's not open data, but data that is protected under certain grounds, like commercial, statistical, confidential, IPRs of third parties, and personal data. This is also where is also very relevant to think about these anonymization issue, because if the data is not properly anonymized, then the DGA would still be applicable. But if I'm talking about open data, because I anonymize it and then I consider it open data, then the open data directive would apply. And of course, if we are still talking about personal data, the GDPR would still be applicable. Who does it apply to? Again, we have public sector bodies, the reusers of the data, data intermediation service providers, which is a new type of role that was introduced by the DGA, the Data Governance Act, and data altruism organizations. Then finally, we have the Data Act, which defines who can create value from the data and the conditions under which they can create value out of it. And here we talk about data sharing between business to consumer, business to business, and business to government. What type of data? Product data or related service data, including IoT data, so Internet of Things data, smartphones, and cars. And it applies to manufacturers of products or suppliers of services connected to IoT, data holders, or data processing services. There are very relevant provisions for cloud and edge computing providers. So we're going to look a bit into each of these acts a bit more closer. And first, starting with the DGA, with the Data Governance Act, which is applicable since 2023, 24 September 2023. And it's very important to know that these providers are considered neutral third parties. That's the most relevant aspect I would like to highlight. So neutral means that they are data space participants that provide enabling services, but they won't have a direct role in the transactions themselves. They will just enable the data transaction. So their aim is actually to establish commercial relationships for the purposes of data sharing between on one side data holders and data subjects, and then on the other side data users. But as I said, they will not be part of the data transactions themselves. And that's why also we exclude here data sharing services offered by public sector bodies that do not aim to establish commercial relationships. So they have to comply with certain obligations as neutral third parties that facilitate the transactions. They might also facilitate these transactions or provide with services like anonymization or pseudonymization, and also enabling the data subjects rights. If we're talking about the enabling services of a transaction that involves personal data. They also need to register at the EU register so that the can officially notify that they operate as data intermediation service providers. Well, there you have the link to the EU register. And they cannot use the data for other purposes than putting it at the disposal of the data users. As we said, they are neutral third parties. And other services might also include the enhancement of interoperability and also act, as I said, in the data subject's best interest. So they also have this role of ensuring that the data transaction is in line with data subject's rights, in this case under the GDPR. As for data altruism organizations, the word altruism already gives us a hint. But it defines the data. It defines also the requirements for individuals and companies that make available data altruistically. For this, there is a European data altruism consent form, and they also need to register as a data altruism or organization. They also have record keeping and activity report obligations, and they also have certain additional information obligations towards data subject, because they are also intermediating, but they don't have any commercial interest as in comparison with that data intermediation service providers. What we're gonna now switch to the Data Act. So we talked a bit about the Data Governance Act, but now looking into the Data Act, which defines the conditions under which data space participants can create value out of data. As I said, it's cross-sectorial legislation that allows business to business, business to consumer, and business to government data sharing. And the most important requirements here under this act are related to interoperability, and you can find them in the articles mentioned here in the slide 33 and 36. There is also an an obligation that I would like to highlight here for the business to government data sharing. Under an exceptional need, there have been also quite some discussions around this exceptional need, and there's still work on the interpretation of this exceptional need. But as per the act, exceptional need is considered when it's limited in time and scope, the data sharing, to respond to a public emergency, and that there is no alternative to obtain such data through other means in a timely and effective manner. This should be free of charge, but if there have been certain costs related to anonymization or pseudonymization that was required, there should be at least public acknowledgement or for compensation for those costs. And then also very relevant new obligation introduced by the Data Act is the data portability to switch between data processing services. This is a very important requirement in contracts to have in mind, and to have actually enshrined in contracts that there is this data portability. And finally, we're close to the end, and I see that more or less I'm keeping the time, so that's good, so that we have also time for you to discuss and work on all this. I have this slide for the AI Act. So under the AI cluster, actually a few months ago, I still had the AI liability directive, but it has it was under proposal and has been removed from the program. But now we have the AI Act, well, let's not think about others. In any case, it's into force, and you know that its applicability is transitional, although there are also currently certain discussions about postponing the application of certain obligations, even discussions about the simplification of this act. But in any case, well, we will see what happens in the end, because we are also waiting for these simplification package of the so-called digital omnibus, and it might have an impact also on the AI Act. But in any case, just to give you a bit of an overview of what is the scope, the AI Act regulates the placing into market and the putting into service of AI systems, and it follows an AI a risk-based approach. Of course, we need to look into the definition of what it's considered as an AI system, and the definition you find it in Article 3 of the Act. But when I say, or when we say that there is this risk-based approach, it means that there are certain AI systems that are considered to have an acceptable risk, and these AI systems are considered prohibited by the Act. Those are the ones related to the manipulation of behavior or that are deceptive. So for instance, AI systems that manipulate behavior in a way. And then high-risk AI systems would be the other category. These are, let's say, these can be placed in the market, but under certain conditions that need to be met in order to be placed in the market. And these are the obligations that you see here, high level in the screen. So they need to go through a conformity assessment. They need to comply with requirements of robustness, security, accuracy, detailed documentation. They also need to work with high quality data sets, human oversight. It's a principle that also needs to be met. They also need to be registered under an EU database. And examples of high risk AI systems are, for instance, those that are able to predict if certain health diseases, or if I'm gonna give a job or not to a certain person. And then we have the category of limited risk AI systems. These have certain transparency obligations, and also they need to also conduct certain other obligations. And then examples here are, for instance, the general chatbots. And then, well, there is also separate requirements for the general purpose AI, but an example of limited risk are chatbots. And then we have the category of minimal risk AI systems, which are, for instance, spam filters. And for these ones, it would still be recommended to follow these transparency obligations and core principles for core AI principles like human oversight or accuracy. You see here in the slide, I put the link to the AI Act Service Desk, which has been recently introduced by the Commission. And it's quite an interesting tool because you can actually, it can serve as a guideline to know if the AI Act would apply in your case or not. So you start with questions on the definition of the AI system itself. So to first understand if I have an actual AI system as per the regulation or not. And then if the answer is yes, then you start moving forward to the next steps and then understanding what are the obligations that apply to your AI system. So it's an interesting interactive tool and resource that has been made available, and that I'm sure that will continue evolved also with the new AI office and all the work that's being done there. So I also invite you to check these resources. So until here, we are closing this part of the session. I hope it was useful so far and that it helped you a bit to understand this whole, sometimes not even easy to navigate for people working in this field, because we are always having also new acts and new novelties every day almost. So some practical recommendations would be to start working on your governance framework. because of course it is very important to understand who is who, and from there understanding then what are the obligations that apply to each of the roles of the governance within your data space, that you also are aware of the types of data and technologies handled and used within your data space. So again, types of the questions that we were asking yourselves before, like, am I processing personal data? Is it proprietary data? Is the data properly anonymized if I'm gonna actually anonymize it? So these types of questions. And then identify also the participants' roles and responsibilities. So knowing the governance, then I can identify what are the types of participants to attribute roles and responsibilities as per the different legislation, the DGA or the Data Act. Also recommendation to define your privacy policy and cybersecurity policy and enforce it. And the most important one, I would say, is to work together with your legal team or legal experts within your team. I think, I'm happy that also today we have certain legal experts, some legal experts in the audience. So I think this is also a good link to the workshop part. We are gonna share with you in a minute in the chat a link to a Miro board where you will have all these clusters that we've been going through today. And the idea is to follow 3 steps. The first one would be to indicate which are the clusters that you consider most challenging. You will have like a little star to drag and to put it on the concrete cluster. And then start sharing the main challenges per cluster. You will have sticker notes to share, and there will also be a kind of a parking lot where you can also include any other challenges that you might have found already or that you have come up with throughout this presentation. And then step 3 will be to elaborate on these challenges. The first steps, we will do it in breakout rooms, so in small groups, so that you can discuss better and exchange with peers. And then the final one on the elaboration and how you're addressing those, we will do it in plenary, so that also the other groups and the other participants can hear about those challenges and maybe recognize also those challenges and even, I don't know, exchange some ideas on how to address them already. So I'm gonna share, or maybe Sil did already. Yes.
Yeah, I'll jump in. Thank you so much, Genoveva. As you, I would probably feel it so that there's a lot of information already that is kind of flying around in our heads. This is really the point to start putting this into context also in your own developments. So as mentioned here, the first step is just to use those stars here to indicate even which of the clusters are more concerning, relevant, and so forth, and later on to elaborate also on some of the points you'd like to discuss. We have a little bit less time, so we'll just update it here to have around 5 minutes and for thinking through the challenges and in indicating those. And I'll navigate to the slides. So the contractual framework is obviously very much connected to the whole point about regulatory compliance, because in theory, this is a matter of what are actually the rules of the game. We talked in the first introductory session around the governance framework as the rules that you set up, and those are basically also based on your it's up to you to figure out what those rules are, but certain things are not negotiable, and this is then coming from the context of the regulation. And now putting those 2 things together into the agreements that actually provide a legal basis for ensuring that you can ensure data sovereignty for individual partners, but also to actually work towards your purpose according to what is allowed is necessary. Just to start with a couple of disclaimers here, the context for our contractual framework is really contextual. It's dependent on the context that you're working in terms of the different domains, the different sectors, the choices that you've made around the business governance and technical layers. And that is then the question about also that you need to see this as a very iterative process. Right now, of course, in practice, well, I mentioned that in theory, you will figure out what is possible based on the rules and then start implementing. But in practice, it works more as an iterative process. You see what is technically possible, what you actually want to deliver as a use case and a business case, and then you check constantly this according to the rules that are in place, and find ways to mitigate the challenges around that, the challenges that we've started to also identify. So the interdependence, of course, on a business and governance level is very much tied to your own business model, again, on the different levels of the entity, the use case, and the data space levels. What is actually included in the data products? What is your organizational form as a data space? How is the governance authority taking decisions on those rules, and so forth. And of course, also on the technical layer, I've brought out here 3 most relevant building blocks that are very much connected to the point about regulatory compliance and contractual framework, meaning the provenance and traceability, identity and attestation management, and access and uses policies enforcement, which actually can technically help to enforce the rules that you have set up within the data space. So with those disclaimers that it's very dependent and very contextual, we're of course not able to provide any specific, let's say, recommendations or guidance for any of the particular clauses that you should include in your contracts. But this is hopefully helping you to think through some of those different areas and then help you iterate it together with your colleagues within the data space initiative. So I'll start by just walking you through some of the different types of agreements within the contractual framework, which should or is good to set up. And then later on, again, provide you with some of the ways how to think through the, let's say, evolution of the contractual framework. The first types of agreements that we know are as part of the framework is the institutional agreements. And here is the context that all data space participants, all of the organizations and entities that are participating in your data space need to adhere to that. There are multiple different types of, let's say again, types of legal instruments under this cluster of agreements, as with, for example, the founding agreement or general terms of conditions. But the whole point about institutional agreements is to clarify what is the purpose, what is the context, and what is the legal basis for actually the data space to be operating. This, of course, needs to also be aligned with regulatory compliance and so forth. But it's also a matter of actually starting to think that what are the common elements across the data space to support legal interoperability between the different partners within your data space. You might, and I've already heard this a little bit, that you might want to leave some freedom to the specific entities within the data space to define the rules themselves. What are the purposes and what are the conditions for using that data or sharing that? But that adds a lot of complexity and also increases the transaction costs for actually facilitating that data sharing within the data space. So you might at some point want to start standardizing this also to set some common elements, some common terms and conditions for data sharing, which then help to bring those transaction costs down. With this context, some of the different types of legal instruments that can help or can kind of manifest in practice the institutional agreements is the articles of association, statutes, consortium agreements, and so forth. But this is also the context that it depends, again, what is your organizational form. If you're establishing a legal entity in the end as a data space, you might want to or need to have some sort of a a legal basis for that as well. But if you're not formalizing as a legal entity and you facilitate yourself as at the moment as a consortium, or later on also as a strategic cooperation or partnership within different organizations, a different type of legal instrument might be useful to then put this collaboration or establish that collaboration also legally. The final kind of legal instrument within this agreement could be also an accession agreement to understand how different type of participants will become part of the data space. But as part of that, there's also different types of agreement-specific clauses for institutional agreements that you might want to cover in those documents. And this is, of course, the background and the purpose. How do you identify different types of parties? What are the different roles? And well, how do you structure this? And what is the policy for admitting them? Already something that was mentioned as potentially also a separate document, the general responsibilities and liabilities across different partners, and of course also some reference to the chosen governance models for your data space initiative. In addition to that, there's this document listed here as a general terms and conditions. And again, this is very much related to the actual data sharing, but also on the data space level, because this might regulate already, again, as a separate way, how to admit different type of the data space participants into the initiative. What is your intellectual property policy, data protection policy, technical standards, etc. It all basically tries to provide a legal basis for your governance framework, which you have then aligned or established. So this is in the end always this aspect of what is actually the legal basis for ensuring that you can enforce the rules that you have defined collectively. And the last point here, as already mentioned, is a matter of around the common elements within the terms and conditions for different types of data contracts, which then leads me also actually to the second point, or the second cluster of the agreements within the framework, which is the data sharing agreements. And here it's the difference between the first one is that it's only actually relevant for those participants who actually facilitate or participate within the data sharing, the data providers, the data users, and so forth. And here the key kind of concept or the document under this cluster is actually the data product contract, which should define on which conditions data can actually be shared and also used. From this kind of context, the kind of different types of clauses within those agreements can be actually a matter of the different type of restrictions for this use, the termination of that contract, different types of fees or different ways to monetize data sharing across these, and the use of that data product, and so forth and so forth. So this is very much on the data product level. But again, as already mentioned, different types of models can be functioning parallelly. Certain things you might leave up to the specific entities to define and set their own contracts for the data products. This, of course, helps also with data sovereignty. But again, to balance it out with the tension of high complexity, high transaction costs, and so forth, you might already provide some type of conditions on a data space level by the governance authority, and then the specific participants will basically need to choose from those list of conditions, what do they actually want to include in their own specific data product contract. I will also mention that some of those kind of legal aspects that you might want to consider as part of the data sharing agreements is around what is actually lawful. Again, connection point to the regulatory compliance building block. If and how do you process personal data? What are the compulsory business-to-business data sharing contracts, and so forth and so forth? Again, this is something based on that already the law can guide, and then you have certain areas of freedom to choose the conditions on yourself. But here also I want to quickly note that, as already Genoveva mentioned, the Data Act here is quite important. Because also the Commission has published model contractual clauses for different types of transactions related to the data that is under or regulated by the Data Act. And this is a very much in evolution and kind of will be we'll also see over time what starts to be set as a kind of standard way, but you can already rely on some of those contractual clauses also coming from the Commission. The last cluster of agreements is around the service agreements of the data space, and here I think it's important to also let's say differentiate between different types of services. There are certain types of enabling services, like different types of value creation services and so forth. There's also the federation services on a data space level, etc. All of those can be regulated by service level agreements. But then there's also those services that are whose particularly focusing on the data or data sharing specifically, talking about different types of data cooperatives, data intermediaries, and so forth, which might need a different type of contractual clauses. Again, this is an evolution. We have also received a note that there will be some recommendations coming by the Data Spaces Support Center to this point as part of the version 3 blueprint. But it's here the point is just to think through these in terms of the different levels of service agreements as well. Which then leads me to the last kind of recommendations and ways to think through this before we go into the breakout sessions, is to think through the contractual framework development in evolution. Think what is actually necessary at this stage where you are, either in the exploratory, preparatory, implementation, operational stage, or scaling stage, because I believe the practical context for many of you is that you're operating at the moment as a non-legal entity, as a consortium. This means that you have probably set up a contractual framework for this type, but also thinking already a matter of sustainability. How might you need to actually transition those types of contracts into a different contractual framework once the pilot is over and you still want to continue operating the data space? Thinking through this already as part of the evolution is important. The second consideration is to think through this in terms of the levels. I think I'm bringing this visualization to every presentation that I'm doing around data spaces, but it's important because individually you're representing obviously different types of organizations and the participants within the data space. You need to figure out what is relevant on your organizational level, concerning your role and interests. You need to also think through as part of the use case level, meaning that the actual services and use cases that you want to develop through this type of data sharing and use of the data. And then finally, the contracts that are necessary to establish actually on the data space level, thinking yourself now as a collective, where the governance authority is taking decisions around what is allowed, what is possible, and what needs to be regulated or will be left open for the individual participants to decide. So thinking through this constantly between those different levels again is important. The third consideration is to make that connection with actual technical building blocks, because the question here is that you need to set up legal documents to provide the legal basis for the rules that you have set up, but implementing those rules can be done technically. Certain things can be translated into machine readable formats and integrated as part of the access and usage policies. Some others might not be possible to translate write into machine readable formats and need to be actually established as a process or with dedicated roles within the data space. Again, thinking this through together with your technical colleagues is important to understand that those two things are not developed in silo. The fourth consideration related to the previous one is also about the technical building block around provenance and traceability. Here it's of course the two sides, the data plane and the control plane of data space initiatives, to understand again that how do you ensure that the legal condition, the requirement that, for example, comes from AI Act to make sure that where is data coming from and how it's actually used can be technically also implemented. So collaboration again between those legal colleagues and the technical colleagues is highly important. The time is really flying, so I will want to right away introduce you to also to the next point about the breakout sessions, where we can then go into also a little bit more in concrete terms how this applies in your specific pilots and what type of questions or concerns you might have. So we have around maybe 15 minutes left for this type of discussion. Again, we'll move to the Miro board. You have the same link that you used beforehand. We'll navigate to the right, and then you'll find different canvases for the group discussions. And the main point is to try to understand how comfortable you are actually already addressing those conditions coming from the law, as well as setting up those rules within the contractual framework, and also then understanding that what type of iterations might be needed. So what we ask you to do is to have a quick write down or provide a comment within the Miro how comfortable you are with this topic, how clear, confusing it is actually to you. Then to describe what are actually the contracts that you have already in place. Maybe things are going well and there's no need for further iteration. Maybe certain areas need more attention. What type of challenges do you face currently? And then what are your plans to actually mitigate those? And here, I think the main point is also to understand that asking for help, it can be also a next step. So just to navigating or introducing you to also to the canvases here in the first point, quick reactions with comments about how comfortable you are with this. Second, which contracts you already have in place. And then what I would ask you to use one post-it for challenge and connect it this with a mitigation mechanism. Welcome back, and sorry for the interruption of any of the sentences or discussions. Again, this is very short time to go into the detail on a very complex topic as it is a contractual framework with all of the different types of clauses. What I heard at the moment is the biggest challenge around working on common practices and best practices, because many of those issues are the same, of course, around the different pilots. At the moment, we have 4 minutes left to close the session, so we don't have too much time for hearing from the individual groups. But what I'd like to mention is that as you had, or also either one of our colleagues or the mentors within the discussion groups, I strongly recommend you to have a dedicated session also to continue this conversation and to put a little bit more details, or as the saying goes, meat to the bones about what is actually missing, what types of challenges you face, and what type of support you might need. If we go to the next steps, we have some recommendations and also suggestions to you. If you can go to the next slide. Of course, there's the general work. This is your own work. Many of those things are very contextual based on the partners that you have involved, the use cases that you're working on. Things need to be figured out by yourself. It's very difficult to provide, let's say, top-down decisions or suggestions from the consortium. So do continue working with your legal teams on those challenges that you've identified, and then based on that, of course, set up your contractual framework. It is as abstract and high level as that. But there is this aspect of what can we do together to also identify common practices and best practices. Again, from the consortium level, it is very rather challenging to provide specific details that could work to all of you, but we can identify common elements through collaboration. So there's a question to you, and I'd like you to just use the chat to indicate whether you would be interested in those type of semi-regular sessions to dive into some of those legal challenges together, do some workshops around mapping common elements, also identify aspects that should not be standardized as such. This is not going into a specific working group type of mode, but at least providing a little bit more time to actually mapping those different type of practices. So do use the chat to let us know whether you would be interested in such a type of gathering, or this is not really helping you. Secondly, of course, as already mentioned, please use the mentors and the meetings that you have with them to raise also challenges or the type of concerns that you might have. And of course, the session should not only be a matter of concerns, but also celebration. So if you found really important or useful tools to navigate through these, do share that, because the mentors can, of course, also distribute that to others if that is okay with you. The final next step is to ask you to also give us feedback about the session. What was good, what could be done better, what is still needed. Any type of feedback around that is very much appreciated. And with that, just 1 minute before the closing time, I just want to thank you again, and also Genoveva for putting this session together and your active contributions around the discussions. We stay in touch about the next step in understanding whether we could actually organize such a session or not. I don't see yet any answers around in the chat about the sessions. Please do still use the chat for this. Otherwise, we don't hear back whether you would be interested in this or not. Let's leave the room open still for a moment, but also already say goodbye to everyone who needs to leave. Thank you so much for participating.